In reality, there are many cases where two people have organized a wedding, lived together as a couple, and contributed money to purchase assets, but have not registered their marriage. So, if a divorce occurs later, will the assets purchased during that time be considered separate property or joint property? Judgment number 82 of 2025 from the Supreme People's Court will clarify this issue. In this case, Mr. E is a foreigner and has a romantic relationship with Ms. Nguyen Thi Ngoc Si. On April 16, 2013, the two of them filed a marriage registration application. By July 2013, they held a wedding ceremony and lived together as husband and wife. However, it was not until August 6, 2013, that they officially registered their marriage according to legal regulations. Before the marriage registration date, specifically on July 9, 2013, Ms. C signed a contract to transfer ownership of a land parcel measuring over 291 square meters in Binh Thuan. Subsequently, on July 22, 2013, the land use rights certificate was issued in Ms. C's name only. Later, when they divorced, Mr. E requested to divide this piece of land because he believed it was a joint asset of the couple. However, Mrs. C disagreed. She argued that the land was purchased before the marriage registration, so it should be her separate property. When resolving the case, the court considers the entire process of asset formation and the actual relationship between the two individuals. The land transferor confirms that they sold the land to both Mr. E and Miss C, not just to Miss C alone. Additionally, Miss C also informed the seller that Mr. E is a foreigner and therefore cannot be named as the recipient of the land use rights transfer in Vietnam according to the law at that time. As a result, the contract and the land use rights certificate are only in Miss C's name. The court also determined that before purchasing the land, the two had a marriage registration declaration, held a wedding ceremony, and were building a family life together. Therefore, although the transfer contract was signed before the marriage registration date, the nature of the asset creation serves the common life of the couple. Therefore, the Supreme Court concludes this piece of land is the joint property of Mr. E and Mrs. Nguyen Thi Ngoc Si. Precedent number 82 also affirms that, in certain special cases, property established before the date of marriage registration can still be determined as joint property if there is evidence proving that both parties have established a de facto marital relationship and have jointly created property for family life. Thank you all for your interest and support. If you find this video helpful, please share it so more people can know and refer to it. See you all in the next videos.